then that property is going to be turned over to my office. It will not be released to Mr. Miller. And that does not mean that he doesn't have the right to see what's on a cell phone, which we're all interested in looking at. We also don't know what else may have been in the purse or the wallet or anything like that. His lawyer would be able to ask us about having access to it too. But right now, we are very satisfied and happy that he has been advised by his attorney to allow us to get that property in our possession. Other terms that were part of the agreement had to do with the vehicle that Micah was driving in North Carolina. That vehicle was actually also titled in another lady's name, Ms. Neosi, who is her godmother. So the parties have agreed that that vehicle will be released back to Miss Diana. It is her vehicle, and that's who should get it. We also agreed to respective restraining orders. These are family court restraining orders. They're pretty standard in most family court cases. For instance, in this particular case, there will be a mutual restraint that no party will dispose of any marital asset or do anything to devalue the asset. That is because what is part of the question here is what part of the marital estate belongs to Micah. And that's what we've got to get to next. So there's a restraining order that nobody can dissipate, sell, transfer any property that may be considered marital. In addition to that, there's also a similar restraining order that goes to the opposite in terms of debts and things like that. Whenever you're in a marriage, you may have the capability of having your spouse be a part of some debt. So there's a restraint on not incurring any further marital debt. And then, of course, there is a restraining order with regard to the protection of people. And that protection of people in this place goes both ways. It is a mutual restraining order. It is not a restraining order in the matter that a lot of people think of as in a criminal case. In a criminal case, whenever a restraining order is issued or a no contact order is issued on behalf of the victim, that means that the person that's being held against has no authority, cannot go around that person at all, period. And they can get locked up on site for violating a conditions of a bond or a no contact order. In this particular situation, because we are in family court, it's a little different. If someone violates a restraining order in family court, you have to put together your evidence and you have to file a petition called a rule to show cause. You have to request the hearing. You also have to serve that person notice that you're making an allegation that they have violated a court order. And then you have your day in court, just like any other trial setting, where you get to present evidence and witnesses, and then you prove or you defend against whether you've violated a family court restraining order. So there's a lot more hoops to it. In this particular case, the restraining order basically is saying that the parties are mutually restrained from contacting the other, that all communications will be handled through the attorney's offices, so there's no need for any direct communication. We're also under a mutual restraint to not go into the area of a person's residence or where they work, and if they do, they're to return and leave if the other person is there. So whoever is there first gets to stay, and the other one needs to return, turn around and leave. Well, everyone is also restrained from making any, threatening, any physical harm or anything like that. By us entering into these restraining orders, please do not misconstrue. That does not mean specifically that someone has already done these types of behaviors. These are formalities that are put into place to protect all parties prior to anything like that happen. So we have not, let me make it clear, not had any problems with Mr. Miller trying to contact anybody or anybody trying to violate any of these terms. These are put into place as a formality on the front end for the protection of all parties involved. It also makes clear what the boundaries are, and then if anyone violates what's written in this court order, they'll have an opportunity to file a contempt action or a rule to show cause. No one goes to jail on site for violating this particular type of restraining order. There were other issues that were asked for, or relief that was asked for in our motion. We've decided to put those, what we call, hold them in abeyance. In other words, we've not given up the right to pursue whatever relief we were asking for, but we've all agreed that we will set that to the side for the moment and that we will come back to it at a later time. There's various reasons for doing that. One thing is to quickly, what we wanted to get was this order that we would have possession of Micah's personal property that's in the, currently in the possession of Robeson County Sheriff's Department. So at this time, one of the things that's very important for the family, and after this, we would like to refrain from answering any questions. I want you to refrain from asking any questions from the family members. Any questions that you'll have to ask, please direct them to me and I will answer them for you. I'm going to let you know right now what we're going to talk about next is actually something that was brought to our attention. We have been so impressed and just so happy with people who have taken interest in this case for good causes, for people who have given us tips, who have sent us information and guided us through various avenues where we were looking for answers for certain things. And the family is very grateful for that. There is still a lot to be done here. There is something that's very important to this family today and is also important to this community, we have learned. And that is, there is a petition going around for what everyone's referring to as Micah's Law. And we want Micah's Law. This is a book that I put together with some information, some research, and things that I've done about Micah's Law. Would you be shocked to know that that very law has already been drafted and has been sitting in the General Assembly and the Judiciary Committee, both in the House of Representatives and the Senate? Don't get too happy. It's been sitting there since February the 2nd of 2020. Now I'm mad. Are you mad? I'm mad. So let me tell you the history. On February the 20th of 2020, what is referred to as the Coercive Control Bill was introduced to the House of Representatives. And I want to make sure I give the name right. I believe it was a former representative, McLean Toole, Toole. He presented that bill read it into the House of Representatives, and what happens after that is it's referred to what's called a Judiciary Committee. Now, the Judiciary Committee is tasked with looking at the bill, seeing what needs to be improved, what needs to be deleted. In other words, going through the process to make sure that it is properly codified and put in, and that it's ready for law. So the Coercive Control Bill, when it was introduced as House Bill number 5271. You can get online and track it. It goes nowhere. It goes to the Judiciary Committee, and it goes no further. Folks, that was 4 years ago. Then again I said, on January the 12th of 2021, House Representative Robert J., also referred to as RJ, May, M-A-Y, the 3rd, he introduced the same bill, Coercive Control Bill. It was known as House Bill 3621. That was 3 years ago. When you do the research on the bill, guess what? It got referred to the Judiciary Committee. Now, normally when it gets there, there should be a subcommittee that is assigned to take that particular bill, to study it, to review it, to bring in whatever advisors or other professionals to help craft that bill and put it into, hopefully, its perfect form. It went to the Judiciary Committee in the House and never went any further. Can't find where it was assigned to anyone or anything. Now let's go back 2.5 years ago. December the 7th, 2021, Senator Katrina Fry Shelley, she introduced into the Senate the coercive control bill. What do you think happened to it? Got referred to the Judiciary Committee. But I need to tell you more about that particularly. And before I do so, let's make sure everyone understands what is the coercive control bill. Coercive control refers to a pattern of behavior used by one person to dominate, manipulate, and intimidate another within an intimate or familial relationship. It encompasses acts such as assault, threats, humiliation, emotional abuse, and isolation. The goal is to harm, punish, and frighten your victim through fraudulent representations. It often refers to specific types of behavior. The Coercive Control Bill, Senate Bill 927, sitting in the Senate right now, offers a definition for coercive behavior. I have reviewed it. I agree. I am a lawyer, so I have some input on that. I agree with a lot of the things that are listed there, but I think they left out a few. The bill itself, whenever it's called status information. It's about the bill that's in the Senate called coercive control. Interestingly enough, after it was introduced and read in by Senator Shelley, if you look at other bills, what happens a lot of times, other senators or other representatives will jump on board. After it's read, you'll start seeing, when you look through the history of it, it'll say, this particular representative or this particular senator has asked for the bill, for them to be added as a sponsor to the bill. I don't see any other name on there for with Senator Shelley. I think part of that has to do with how the public, as well as maybe our legislators, as well as our police department, are not educated to this form of abuse. It is real, people, and it is real damaging. Now, the interesting thing is back in 2019 and 2020, both of those years, I want to say it was WBTW, did a series on coercive control, emotional abuse, psychological warfare. Also running for re-election, I believe, at the time was Senator Luke Rankin, who, if you'll recall, pointed to his opponent and said he was involved in domestic violence. Seems to me that that was on his mind. Do you know who is in control and who the chairman is of the committee on the judiciary in the Senate? Luke Rankin. he has the ability to assign this bill to a subcommittee. He has the ability, if he wanted to put it on his agenda and walk it all the way through and make sure it gets done. This bill has been put in a folder in a dust-covered box in a back corner of the closet in the Judiciary Committee's office. I challenged them to go back there and find it and bring it out and assign a committee to it. Let's get this done. It is important. It is extremely important. Now, going back to the bill and how it defines controlling behavior. According to this proposed bill, and granted, this can change, and this bill does need some work, okay? But it's a start. It's some bones. It's something to deal with, or to start with. Controlling behavior also, excuse me, I want to go to the next thing, which is types of behavior. This bill lays out types of behavior to look for. Now, I don't know if you saw or you remembered, but there was an interview that was done of me that said, hey, do you think, what do you think about the police and what they did? Well, here's what I think. I think the police didn't have anything to look to. They show up, they look for bruises. They look for black eyes. They look for scratches. They look for those types of things. And not seeing any, no crime here. They don't have a law to look to. Now, let me read you some of these behaviors that had this been a law at the time, the police officers would have had something to look to and to gauge it. The offense of coercive control of another person may include, but is not limited to, the following types of behavior. The very first one, isolating a person from their family and friends. In and of that self, that is not a crime. Next is depriving a person of their basic needs, food, shelter, clothing. The next one is monitoring a person's time. That's done a number of ways. Trackers, PIs, looking through their cell phones, looking at what they're doing online, driving by the job, who you talking to, where you at. D, subsection D, monitoring a person via online communication tools and using spyware. The interesting thing here is when people are married and the police are called to a domestic situation, usually what happens is they're told by the police officers, because this is what they get to go to, is, ma'am, sir, this sounds like a domestic issue. You need to go see a family court lawyer, or you need to go file something in family court. Well, the first thing that a coercive control abuser does is take away your money, take away your transportation, and your way of communication, and the friends that support you. How are you going to get there? How are you going to pay for it? Going on to the next one, E says taking control over aspects of a person's everyday life, including where the person may go, who the person may see, what a person may wear, and when a person may sleep. Next is depriving a person access to support services and medical services. Next is repeatedly insulting a person, including expressing the person's worthlessness. Enforcing rules and activities within the home that humiliate, that degrade, and dehumanize a person. Next is forcing a person to take part in criminal activity, including shoplifting and neglect or abuse of children. Children are often used as tools and weapons against the one that they want to dominate. They also encourage the person's self-blame and prevent disclosure to authorities. If you tell, this is what's going to happen to you. Next is financial abuse, including control of finances and only allowing a person a punitive allowance. You don't need to get your hair done. It looks fine. You don't need the money for that. You don't need a new set of boots. You got plenty. Next is threats to hurt or kill. That's a lot. Threats to a child, threats to reveal or publish private information or extort the person or a member of the person's family in retaliation by legal or other means. Assault. Most people think of assault plus the battery, assault and battery. Assault is in the fear. Someone placing you in fear. Raising my hand, my fist to you. You're afraid I'm going to hit you. That's an assault. Usually what happens after an assault is the battery, where the hand or the fist comes down. Assault doesn't leave bruises, but it sure does on the psyche of the person who's experiencing it. After that is rape. Non-consensual, of course, that's what that means. Sex that both parties don't agree to. There's no past when you're married. Can't go to their mamas. They can't, go see their friend who's their confidant or the one that they can lean on. Can't take the children to the daycare to get to the job. Transportation impacts a lot of areas. Those are the types of behaviors that are listed by this bill. I have developed what's called Micah's list. Micah's list tracks what the bill says. And we put together things that she journaled, diaried, or put together to say happened. Please keep in mind that John Paul Miller has never been arrested for domestic violence. He's never been arrested for any harm against Micah. And everything that's put in here, quite frankly, is her words on paper. I have no reason not to believe her, but in fairness, you need to understand that what I'm about to read are things that Micah alleged in her writings and journal. I'm not going to go through the ones that we just went through. I'm going to go through the ones that I suggest and recommend that the Judiciary Committee consider asking the subcommittee that hopefully will be assigned very soon to consider. General emotional abuse. All of this together is emotional abuse, psychological abuse. It's psychological warfare. Ignoring requests and commands to stop, to leave me alone, go away. Cruelty to your pets. That one's used just like children. Destruction of property. Keying cars, slashing tires, whatever that may be. Destruction of the supporting evidence that the alleged victim had in mind to use against the perpetrator. Misuse of legal documents. Sending letters such as cease and desist to threaten to file lawsuits or threaten to take other legal action is an improper use of the legal system. I don't know how many people would ever get a letter from a lawyer that would not be concerned or afraid. That's what we do when we send those letters. We threaten to sue you. Next, I would suggest is misuse of legal documents. Excuse me, I'm sorry I said that one. Misuse of law enforcement. Calling the police for no reason. Gaslighting, saying something happened that didn't happen. Telling somebody they can do something, then turn around and call the cops on them and tell them that you didn't say that. Whatever. That's such a waste of time of taxpayers' money. Now, law enforcement need to be doing other things than that. But it's intimidating. And then you find yourself, you're having to defend yourself against something you didn't do. Misuse of the legal process. Filing divorce actions, dragging you in the court, dropping them, filing them again, dropping them, filing other papers in the court. Using the court system not for legitimate purposes, but for purposes of intimidation and control. Another factor should be adultery, promiscuity. Another should be stealing a person's identity. Folks, do y'all know in today's time, technology, we can control everything from our phones. We can start our car. We can slam on brakes. We can turn up the heat and we can turn down the cold. Our domestic violence statute is archaic. We got to get it up to times, up to today standards, taking into consideration all the things and ways that a person who wants to control and intimidate can use. I would refer to that as cyber or technology abuse. Medical abuse, making a person take medication that they're not prescribed, making them do other things, denying them access to medical care. Lots of different things that could happen there under medical abuse. Spiritual abuse. Spiritual abuse. The next one I'm saying church abuse, but it really should say position of authority abuse. If your loved one works for you or you work for them, they have a position of authority on you. Fire you like that. You don't like what I say to do? You don't do what I tell you to do? You just lost your job. And then whenever you go and do all this list of things that I want you to do, I might let you come back. That's also financial control. Phone calls to everybody to explain everything. Called your mama, called your sister, called your brother, called your daddy, called your lawyer. Called everybody. Explaining. And the last, of course, from my perspective, is physical abuse that doesn't leave marks. The shove against the wall, the hand around the throat to hold against the wall just long enough and tight enough where you can't move, but it won't leave a mark. Holding you down, won't let you up. Those are physical abuse that don't leave marks. The police come, they don't see marks. They can't do much. This will give them the tool that they need. It needs to be education about what coercive control is. Someone who's not lived in it or been a part of it sometimes has a difficulty wrapping their mind around what this is. Coercive control is basically like a psychological warfare. It will damage the very soul of a person. It will make them doubt and lose their self-confidence and especially their self-worth. And they'll give up. They'll give up on being happy. And they'll survive and trudge through day by day, or maybe they won't. What this family wants you to do is to help this. We want Micah's law. We want the coercive control bill to be looked at, taken seriously, put some time into it. And somebody make an amendment You add your name as a sponsor and make an amendment to call it Micah's Law. And what can you do? What can each of you do specifically? Sometimes we feel like we're not effective. We can't do certain things. Getting this law on the books will help. So, what we have done I'm just going to show you. These are purple folders or envelopes that have all been stuffed and addressed to every member in the House of Representatives that are on the Judiciary Committee. There's also one in there for every senator that's on the Judiciary Committee. So y'all look for your purple envelopes. Now, what the public can do here is hold your legislators accountable. What have they been doing? Take a look at it. Contact your legislators, both in the House and in the Senate. Let them know you're mad. Let them know you're on board. Let them know that you are their constituent, and if they want your vote next year, they better get this done. You can call them. Their numbers are published online. The website to go to is www.scstatehouse.gov. If you don't know who your senator is for your district, if you don't know who your House or who your representative is in the House, you can go on that website, put in your address, and it'll tell you who that person is. So I would encourage you to reach out to whoever is representing your district in both the Senate and the House. But don't forget those who are on the Judiciary Committee. So go there and you can look for the Judiciary Committee, both in the Senate and the House. You'll get the names of everybody there that's serving on that committee. They make it very easy. They have a place online there where you can submit an electronic message to them. You don't need to go and do all of this work. You can simply go online, fill out the form, submit it, and they'll have it. If you want to do a letter, but you just don't know what to say in it exactly, I have created a template form that is available for anybody who would like it. You can use it just like it is, or you can change it up, or you can use it as inspiration and write whatever you want. But please get those letters out there. You can also send them an email saying the same thing. Those email addresses are published on that scstatehouse.gov website. And then next, just put it on your calendar every now and then. They have a thing called tracking that bill. Track that bill. Thank you to everybody for being here and for your patience. I know everybody was looking forward to seeing the drama in the courthouse or in the courtroom. There was never going to be any drama in the courtroom. It is not a live testimony type of hearing. Nobody got on the stand. Nobody would be cross-examined, that kind of a thing. It's simply a packet of papers that would have been presented to the judge while we sat in silence, while she reviewed the information and made her decision. So we do appreciate you standing out here in the heat, too, and waiting for us. At this time...
The restraining orders that went out today, where were those for Micah? Because you represented her, so where were they?
No orders had been signed by any judge at this time, or at that time.
How come they didn't go out for Micah, though?
There was a request for restraining orders for Micah, but unfortunately Micah passed away before we got to court. But the request was there. So, as I said earlier, what we would like to do is keep the focus on the coercive control, i.e. Micah's Law, I'm happy to answer any questions that anybody has with regard to that. We'd like to keep the focus there. If you have questions for the family about anything else, we would ask that that be done at a separate time. Yes, sir, in the back.
This relates to Micah's law. Do you believe the FC justice system failed Micah? Current FC justice system. Do you believe that Luke Rankin, who is head of one of the leadership of the judiciary, is ahead of right here represents the he's done more to seek to reform some good calling for, or are you looking for some good calling for?
Yes, that's a very good question. So, as it always is, there's two sides to every story, right? There's the side of the story that the position that the family takes that Mr. Miller is somehow responsible for her death, whether that's directly or indirectly. Obviously, it's been declared self-inflicted, so that is off the table. There is questions about whether this type of behavior would drive someone to take their own life. We do not know what was inside of Micah's head. Of course, her husband takes the position that she had a mental illness, that she didn't have her medication, and that the reason she did what she did was because of a mental illness, specifically bipolar. So to say that the judiciary failed her, because I don't know what really got her to that point, I have some suspicions, but I do know this. Based on all of the stuff that I have reviewed, the things in the journals that Micah left in my possession, tell me that a lot of these behaviors happened assuming that what she said was true, and I have no reason to believe it wasn't. If the law had been in place at the time, she could have reported these types of behaviors, and the police would have been able to look to that particular law, assuming that when it went to the governor for signature, that it would be in the same format or better or harsher or whatever. So I think that is a possibility, but to say for certainty is not possible. What I do know for certainty is that there are people who are being victims of manipulative and psychological abuse that's often overlooked, and this bill will help every one of those people, and that's husbands, wives, women, and husband or men as well. So it's not gender specific. This happens on both sides.
Regina, do you know if this kind of law is in other states, this kind of protection?
Yes, thank you very much for asking that. I actually meant to touch on that. When I mentioned about WBTW doing their special on this type of abuse back in 2020, I believe it was, interestingly enough, go look it up, South Carolina made headlines for being one of the 4 states that was considering coercive control. Of the 4 was South Carolina, Hawaii, Connecticut, and California. Guess who's got laws on their books? Probably 3 years old now. Hawaii, California, and Connecticut. South Carolina doesn't. What did we miss?
Attorney Ward, if Michael's law gets passed, would it apply retroactively?
I wouldn't say that it would. Of course, it's up to the legislature, but I'm pretty sure that would not be fair to anybody, anywhere. Usually whenever a law is passed, or a bill is passed and signed into law, it usually comes with an effective date. So there would be some date that would be picked, and from that date forward, anything that violates that bill could be considered, part of, if that's a crime. Yes, sir. I'm sorry.
I've got a court document here from Surfside Court, Magistrate Court. On March 26th, Mica Miller filed a restraining order, which was dismissed without prejudice. You represented her at the time. Can you comment on why that was dismissed? Would this law have changed that?
I think that's a little bit of a misnomer. This is another part of the problem, is whenever you are married and you're being harassed by your spouse, and you can't get into family court or whatever, most people think about, hey, when somebody's harassing me, we all know you get 3 events. You go to the magistrate court and ask them to issue a restraining order and tell this person to leave me alone, right? That works really well for your neighbor or your whoever that's bothering you, because you can show, hey, they texted me, I said, don't text me anymore, and right after that, they sent me this long diatribe, okay? So whenever people who are married go to the magistrate court seeking that type of restraining order, they can fill out the paperwork, but then the judge will most likely look at it and say, this sounds like a family court matter. Why? Because you're married. And so they feel that the jurisdiction really belongs to the family court. Now, there is a small exception to that. If you look in the law, it says that the magistrate court can issue those types of restraints like family court can whenever the family court is closed. So usually the judges like to stay in their lane. They don't want their orders overturned and that sort of a deal. So if it's a possibility to refer them to a family court when they're married, that's what they're going to do. She just went to the wrong place for that. And no, I wasn't representing her at the time, but I wish I would have been. Yes, ma'am.
So can you talk about the testosterone allegation?
I'm not going to talk about any of those things.
Well, what portion of the law, of Micah's law, would apply to those allegations?
Okay, so as it's written, would probably be assault. Okay, the suggestion that I asked to be added would be medical abuse or that type of thing. It's also a form of battery whenever you administer somebody something against their will. Battery, actually, you know, people think of a battery as it leaves a bruise. If you do this to me and I don't like it, that's a battery. If I told you not to touch me and you did, that's a battery. You accidentally bumping into me going down the hall is not a battery. It's an intent. Yes, ma'am. Thank you. Okay, thank you very much. That reminds me of something else I should have told everyone, is we have set up the email address. It's called Justice for Micah Tips, TIPS. That's, of course, it was set up for people to send in tips. But if you want to send us an email to that particular email address, and so we can get your contact information, and we'll be in touch with you, okay? Thank you so much. Yes, ma'am.
First of all, does it equal the same thing as domestic violence? Like when the police show up, do they say, okay, we can arrest right now because we have this law, or do you still have to go?
Yeah, very good question. Thank you for that. Okay, so this law, if it goes into effect, will be considered a felony. The suggestion is that it carries up to 10 years in prison. With it being a felony, police can't really lock up on sight. If the police see you committing a crime in the front of their very eyes, of course they can arrest you for that. But whenever it's this many levels of elements and proofs that are required, what would happen at that point is the police officer would say, this seems like this might be coercive control, and then go to a magistrate who can issue a warrant if the magistrate determines there's probable cause. So if the magistrate compares the facts and things that are being relayed to him by the officer, then the magistrate would have the ability to issue that warrant and go from there. You've already been there. Okay. Yeah.
Just for clarification, S927 is the bill that you're supporting. You said it wasn't quite right, but you said it was a good start. That's the bill you want amended to be Micah's law. And do you want to see changes to it? Do you want to see a new bill? Do you want to see senators reaching out to you and kind of craft this legislation?
Thank you for that question. I had actually, in the letter that I'm sending to them, making some of my suggestions. I'm happy to read it to you if you want to hear it. But basically, the clear goal of the bill is to avoid any person from being psychologically and systematically abused. I had come up with 16 additional factors that I felt like were missing from the bill. I also believe that the bill needs to include mandatory ankle monitors for those who are arrested. Obviously, the person is, most likely following you around and doing things to intimidating, riding by where you are so that you see them. So I think an ankle monitor would be a good part of a condition of a bond for someone who's been arrested for that charge. I believe that it would be prudent to require that a portion of those fines and those fees and those ankle monitor costs and anything else associated with should be allocated to a domestic violence fund. We used to have CASA here, Citizens Against Spousal Abuse, and the funding sort of dried up. So it's always a question of how do we pay for these things. So I think that a percentage of the fines and the costs and things associated with that type of charge should be allocated to a domestic violence fund. I think the funds should be collected and paid to use as salaries to hire at least one attorney in every county of the state of South Carolina to offer free legal representation to victims of domestic violence. Coercive control is actually a part of the domestic violence statute that we have. It will be a part of it. So it's not a separate thing. It's actually requesting an amendment to the South Carolina domestic violence laws. In other words, adding another section to the title. The additional thing that I asked for in there is, I already said basically, is to try to get some representation because people are confused by the legal system. And so it would be really nice if they could count on legal representation whenever they don't have any money, they've been cut off financially, they've been cut off, transportation, etc. So those are some of the things. I also think that they should look at things like wrapping up first offense, second offense, third offense, those types of things, and making it an enhanceable crime. Okay, just a couple more. We're all baking out here, so thank you.
About how the criminal justice system has ruling exempt suicide. The family intend to use the civil court system to hold, or to attempt to hold Pastor JP civilly liable for the death.
As I've stated many times, we're collecting information to determine whether that will happen. I have been retained for that specifically, but right now we're just in a research and investigative phase.
Thank you.
Yes, ma'am. Yes.
And I just want to say that there are so many people in the community that try to help victims. I'm one of them. I pay for
Wonderful.
just so that they just don't forget how those really leaders that was
Absolutely. And this coercive control bill is just an extension of the existing domestic violence that covers the physical abuse as well. And so it would just be another extension or leg of it. Yes, ma'am.
What is going to hold the police accountable, even if, because obviously this law is taking time? But how can we make them aware? How can we, we're doing it now.
Mm-hmm.
They need to be held accountable too, to be more
responsive,
perceptive,
yes.
Of what's going on. And sometimes if somebody has a lot of money in the community or a lot of time, they will take sides. So.
Yeah, thank you for the comment that the abuses, victims are, all, it's somewhat rampant. So it's not just about Micah. So no one's being forgotten. It's all about victims. We're just asking for it to be called Micah's Law because so many people have paid attention to this situation. all eyes are on it and people are paying attention. And we really want people to become educated. We want our police to be educated. They're not trained in it because it doesn't exist in law. They're trained to a crime, okay? So when we say hold the police accountable, as I've stated before, when they arrive on the scene and, you know, a spouse is saying, she took my wallet and won't give it back and has my keys and won't let me leave the house, then the officer is going to diffuse the situation, okay? And it's a domestic situation. People get in fights, you know, and fuss. I mean, it's part of being married too. Doesn't mean it's all abusive, but sometimes it gets, you know, to a place where someone calls the police because they want something to happen. And so the police will look at it and say, well, I don't see any bruises on you, sir. I don't see anything like that. Did she hurt you? You know, that sort of thing. So if it's not a physical abuse thing or a physical manifestation of the abuse, the police just don't have anything to look to. So would this bill be made into law? Of course, I would imagine that there would be some form of training because it would be a new law that they would have to be familiar with and learn how to identify the elements that are associated with it. I think you had a question.
Yeah, when a marriage occurs, obviously the spouses get a lot of protection. You sort of alluded to how they would say something like, oh, it's a domestic matter. How exactly does the law change how a married couple is, how complaints within a married couple are handled? Other than, I mean, obviously it's new protection, but does it change regarding marriage?
Right. So I don't think anybody should be afraid that if I call the police saying, you know, that this particular thing is happening when it's really may not rise to the level of a crime, you know, she's yelling at me, he's yelling at me, won't leave me alone, kind of a thing, whatever is going on. With this bill, what happens, as I said before, the police cannot do anything about it. What they do is they will look at the totality of the circumstances, okay? It's going to require that there be different things. I think if you saw me say, when the police show up at your house 15 times, something's going on, okay? But the police don't have anything to look to say, what does it mean when you go to the house 15 times, okay? That would be an element to prove coercive control. That would be one of them. So, and the law needs to figure out what the combination is or how many things. I think there's a suggestion of 2 behaviors. You know, I don't know what it'll end up being. Maybe that's too many, maybe that's too few. I don't know. Okay, so it is super hot and
Regarding protesting on the protest last Sunday, is that helpful, not helpful? Could you guide us there with what the family's wishes are as far as moving forward with things such as that?
yeah, thank you very much. I haven't spoken to the family specifically about that, but I think I have an idea of what they would say. They want your support here. You don't need to be running around Mr. Miller's house and his back door and across the church, okay? We've already got the message out, and Micah's life is going to matter, regardless of whatever the reason was of what happened to her. Her life is going to leave a legacy, and her life is going to help people. That's where we need to focus now. We need to focus on that, because the other things that happened or may happen, we can't undo those. We can't undo those things that allegedly happened to Micah. But what we can do is going forward and being supportive that hopefully there won't be any other victims that got to this level. That's where we need to focus now.
Is it true that the FBI is investigating through death or they're not? Because there's a lot of speculation going around that the FBI is investigating for death versus just other situations going on.
Yeah, we're getting away from coercive control, Bill, with that question.
Can you send me an email one more time where people can reach out?
Justice for Micah, TIPS, TIPS,
So,
at gmail.com. I apologize.
so current state law states that if you want to get someone convicted for stalking and harassment at least, you have to show 2 or more patterns of that within a 90-day period. It sounds like Micah, I mean, she made multiple police reports. I spoke to Jimmy Richardson, the 15th Circuit solicitor. He said that stalking and harassment here in South Carolina, that's pretty easy to prove. So, in your perspective, why weren't any arrests made?
Well, I can't speak to that. I'm not the authority that was there to, police officers make judgment calls on when to arrest someone. If they're not sure or if they see, different types of behavior that require an issuance of a warrant, or they've learned of different types of behavior that may issue a warrant, then that's what the police, that's what's available to them to do. Okay, thank you so much to everyone. We do appreciate your support. We appreciate you standing out here in the hot and bearing with us. This is an important thing. You want to make a difference in this world. You want to make a difference for your neighbor, your loved one.